So, Will, I'm, yeah, as you know, I'm not a lawyer, and I've never taken a case to court, if that's the right word. Certainly, I have within data protection, actually, but not within homelessness. And I always assumed that you had to be a lawyer, and and it's obviously very difficult to get lawyers sometimes to actually get involved and actually help people out. So we've kind of always we've relied on the idea that we get the decision overturned before we get that far. But as I understand it, and as you were about to try and explain to me, actually you can certainly you can go some way without being a lawyer. You don't there's some work you can do as any layperson can to kind of get the ball rolling and certainly set a solicitor up well to kind of take it on down the line potentially. So do you just want to kind of and just treat me like an idiot, because literally all this jargon is going to go over my head? So what you kind of call it a pre-action protocol. What does that mean? What does
Yeah.
it cover? How does it work? And let's give
Well,
an example. So let's say we're supporting someone who we're pretty sure is vulnerable. They've got multiple health issues, let's say, and yet the council's just digging the heels and they're saying, for the sake of argument, let's say they're saying that there's not even reason to believe that they might be in priority need, so they're denying that person Section 188 temporary accommodation, and as a layperson, you're like, well, there's no right of review here, we're stuck. So that's when you might be able to kick in here.
yeah. So to start off with, as you indicate, there's two different possible terrains for having a fight with the council over a decision. The first would be the internal review procedure, which comes up where they've made a decision as to how they've discharged their duties, basically. And the Housing Act 1996 introduced these procedures precisely to keep, because the administrative court was just getting clogged up with homelessness cases. So they farmed them off to the county court. So arguments about whether somebody's in priority need or intentionally homeless, or whether accommodation that they've offered at the end of the application is suitable, those all go through review, as you know. Anything else that isn't covered by review comes under judicial review. Now, judicial review, I think realistically it's impossible. I mean, I'd be impressed if somebody could do it, and it'd be nice to see if they could, but I think it's impossible for a member of the public to run a judicial review themselves. You've only got to go to the High Court where judicial reviews take place and try and find your way around there, let alone do any work in there. It's designed like a cathedral. It's like they chose the wrong type of building when they were setting it up. They thought they were building a cathedral, but they built a court. I still get lost in it. I've been going there for years and I still get lost. And occasionally, like a sort of department store, they change the rooms around and you have to find the issue room. But fortunately now I don't have to go there so much because I can do it online. But so the procedure is, you have to, in a nutshell, you have to issue an application in the administrative court and say to a judge, this is what the law is, this is what the council have done, this is why we think it's wrong, and this is what we want you to do. And say in your situation, we'd be saying, law says this about priority need, this about homelessness. The applicant is priority need and homeless. The council have either they haven't even done a decision letter, they just told him on the phone to go away. They should have done a 184 notice, they should have made inquiries, and the judge will say, we want you to, or we would ask the judge to make an order to process the application properly and to provide suitable accommodation pending the outcome. And if only it was as easy as that. I mean, but what you have to do is put all that together in a legal document, which I tend to get a barrister to do, and then because only barristers have rights, or some solicitors have higher court rights of audience, so they can go in front of High Court judges. But I personally can't. I wouldn't be allowed to speak if I went to the High Court. So if I'm going to ask a barrister to speak, I tend to ask them to do the preparation so they're not embarrassed by my making a mess of things. So you then do all of that. But before you do that, you have to write a warning letter to the council. And this is what we were talking about, the pre-action letter. And it's called a pre-action letter, well, partly because it's sent before action, but there's a thing called the Judicial Review Pre-Action Protocol, which sounds quite daunting. But in a nutshell, it means that you have to warn the council of what your grievance is and what you're going to do about it. And you normally have to give them 14 days, but you can give them less. For instance, if the person's out on the street, you could give them half an hour. You could even not even bother. I mean, you'd be foolish not to, because you want to send a letter off. And there are quite a lot of predatory solicitors out there that will try and issue court cases where they didn't need to. All they have to do was ask, will you give them somewhere? But then they get costs against the council if they win. So the protocol is designed to stop wasting judges' time where solicitors are either being a bit predatory or lazy and not bothering to tell the council. So you send this letter, which if you read the protocol, you think, oh God, where do I start with that? But actually, it just comes down to 3 categories, really. You say what the problem is, what the law is, and what you want them to do about it. And then at the end, you say, if you don't do this, I'm going to go to court in 2 weeks. I could show you one of those if I share my screen. I write about one of these pre-action protocol letters every day, or probably every other day. Some weeks, I mean, one day about 2 weeks ago, I sat down and I just wrote about 4 or 5 of these in one day because I had to. And sometimes, as a lawyer, when you're dealing with the council messing about, there's not much point in me writing to them saying, can you please do this? Because they may well just ignore it. And they may think, who does he think he is, sort of telling us what to do. So the best thing is, if I'm going to be nasty, I might as well be nasty while I can still be nice about it. So I'll just send them a pre-action letter straight away. And they may say, how dare you suggest legal action? And I said, well, I'm a lawyer, that's what I do, I'm sorry. But I can be nice. Somebody rang me up from one of the councils today and said, when does the deadline? I've been away, I've got your pre-action letter. When's the deadline again? And I looked it up and I said, oh, it's tomorrow. And she said, oh, I'll have trouble getting back. Can I have a bit more time? So I said, yeah, of course, we can extend it till the end of next week if you like. So you could then be nice about it. Whereas if I wrote her a letter saying what's going on, she probably wouldn't have bothered replying.
Yeah.
But then I'd have had to threaten to make a complaint or something. So it all worked out in the end. And this is a standard letter that I use where the council have just refused to process a homelessness application. Is if you look at the headings, that details of the matter being challenged. So you can imagine in there, I put Mr. Bloggs applied to the council last week. He did it online and he got an email back. And then when he rang up to say what's happening, he was asked a few questions and then told it doesn't sound like you're in priority need. Sorry, we can't help you. And so then I would say the issues just sets out the different legal requirements. Section 184 says you've got to make inquiries. Section 184 says you've got to give a written decision. Section 188 says you've got to give temporary accommodation where you've got reason to believe. Section 211, I keep meaning to take that out of the template, but it is quite important. Sometimes it comes up. It's the duty to look after their belongings. And then section 189A, my favourite new section, the one to carry out an assessment of their housing needs and to draw up a personal housing plan. And then I say at the end of that, council, this is where they've refused temporary. So I'm just reminding them why they have reason to believe that he's homeless and eligible and in priority need. So I put he's eligible because he's a British citizen. They have reason to believe he's homeless. Usually I put because he's told them that he's got nowhere to stay, and that should be enough to be going on with. Yeah. And he's in priority need because either he's got a child living with him or his medical condition. And then I say, I believe you've known about this since, and I put maybe 2 weeks ago or whatever he replied. And then I say, it seems to me that you haven't processed the application, and I believe you are under a duty to do so. So then it says action which I expect the council to take, and I expect the council to process Mr. Bloggs' application and provide him with temporary accommodation. And I usually put here Mr. Bloggs' telephone and email addresses in. And then I give them a deadline, and that's it. And I have another letter that goes to the legal department, or this would be sent by letter, although I hasten to say it's sent as a letter document. I would email it, but sometimes things look better being sent as an old-fashioned letter than an email, especially when you want a judge to read it later. It looks better if it's on a letterhead and looks official. Yep. And then I email that to the legal department. And then this is a real blessing that we have as solicitors, is that you take it out of the realm of arguing with a housing officer and send it to the legal department and say, I'm sending you this letter because it's threatening legal action against your client department, and I'm also going to claim legal costs, and I wouldn't want anyone to think I hadn't warned the legal department before doing that. And so could you see if you can get instructions and resolve this case? And what will then happen is the legal department will contact the housing saying, we've had this letter and help, because they don't want to be negligent. And somebody say, well, we got taken to court, but the legal department didn't warn us. So they'll say, what can we do to solve this? And then you'll normally get a response really fast.
Yeah.
To a situation, and maybe, I mean, some councils, usually the outer London ones, I got one, you know, I did a case against Gravesham. I mean, they don't do so much. I mean, they're nice people, but they get it wrong, and they sent an email back saying, sorry, we're not going to help him. So
Right.
I literally did get to the door of the court on that one, but because I think they're good people, I warned them and I said, look, here's the court papers. These are going into court in an hour if you don't agree, and they back down.
Okay.
So once I've sent that, I let the time limit run out, and then what I would then do, thanks to email and stuff, if I've given them 2 weeks, I would warn them after 1 week and say, hello, remember me? I said I was going to take you to court in 2 weeks. That was a week ago. You're running out of time. And then you've got a nice paper trail to show to a judge, because usually you'll get a lawyer writing saying it's outrageous that Mr. Flack, he didn't tell anyone he was going to do this, and he's run off to court, wasting our time. And I can say, look, I've sent this and this and this. So that is a pre-action letter. And there's a variation. If you think about every problem that you come across, you can normally just change that bit and the facts of that bit. So in my library of protocol letters, I've got about, I think that was 7. I've got about 8 or 10. I mean, there's the traditional refusal to carry out a Children Act assessment, refusal. There's the bed and breakfast as temporary accommodation one. It often comes down to, and there's suitability of accommodation, because the crazy thing is, in terms of that split we had at the beginning, if you're challenging the suitability of temporary accommodation under section 188, which is given before they make a decision as to whether to accept a full duty, that can only be challenged by judicial review. Whereas if they've accepted a duty and they're housing under section 193, then you can go for a 202 review. But you may say, well, hang on, there's 202 reviews not much good, because they've got 8 weeks to carry that out. And if somebody's living in a terrible place, you don't want to wait 8 weeks and then have a homeless appeal, which could take another 3 months. So you could, in theory, I haven't done this much, but you could do 2 things in that situation. Send them a judicial review letter anyway, and say, I know that I should go for an appeal, but an appeal is going to take 6 months to be completed once I've completed the review process and everything. And I don't think that means that there's redress available for this grievance. It's just not, it's not a remedy to say wait 6 months if the person's in unsuitable accommodation. So we're going to go for a judicial review anyway. Or alternatively, you say this accommodation is so unsuitable that it's not reasonable to continue to occupy, and they're homeless again. So you've got to provide new accommodation under section 188. So they don't usually fight that too much. In fact, I had one the other day where I asked for a review of some accommodation. They said, no, we won't carry out a review, but we'll carry out a fresh homeless application. And of course, nobody got back to the client. So I've then had to send a pre-action letter saying, well, you've accepted a mandatory duty and we'll take you to court. It'd be interesting to see what happens on that. But is that helpful?
Yeah, it is. I mean, so just so I understand the kind of those key steps. So again, just kind of based on that example I gave before. So the council said that there's no reason to think this person even might be in priority needs. So we're not even going to, we're not even going to consider TA. So you basically your first, I mean, you essentially write this letter and send it to the legal team. Is that first thing, or do you kind of warn them?
I send it to the housing department. The one I just showed you that I set up there, that goes primarily to the housing department for the attention of the manager. And that's politically quite useful as well, because you send it to the officer if you've got their email address, and maybe send it to their central email. But because it's gone to for the attention of the manager, the caseworker has to sort of report themselves to their boss and say, oh, I've had this letter in, it's for your attention. Because if I go to court, the manager's going to say, why didn't you tell me about this? So that it's immediately sort of escalating it. But then a copy of that goes to the legal department as well.
Right. Okay.
With my second letter, which says, please, can you see if you can sort this out?
Yeah. And so you say you've got that time limit of 2 weeks in this case, although you might want to go for a short one with somebody who's actually out sleeping rough. But and then you know where possible you'll give an extra reminder. So just that clear kind of paper trail for a judge to see that you've been reasonable and you've not just been trying to jump down the neck of the the first mistake you saw. You've actually trying to get a good outcome before that.
Yeah, I mean, I'm tending to find, and there was a bit of a clampdown a couple of years ago, because the courts got fed up with cases which got issued, and then the council came out with their hands up day after the case was issued, saying, "Well, if you told us about this, we wouldn't have needed to go to court. You wouldn't need to go to court." So they said literally, because there's quite a lot of councils where somebody makes a homeless application and nobody hears anything. They'll say, come back tomorrow, and there's nobody there or something. Or the person you need to see is out, all that sort of stuff. And so then people go, so, okay, fair enough, it's $1 in my pocket, we'll just JR them and get an order. But then the judge would nowadays say, well, what exactly did you do after that? Did you phone the manager? Did you phone the legal department? You can't just go and say, nobody got back to me. You'd have to demonstrate, and even the emails isn't quite enough. Because on that Gravesham case, I did actually ring up before I was going to issue and say, because I knew, I've been around enough that I know most of the numbers for the legal department and stuff, so I got through to them. So yeah, that's the thing. You've got to give quite a lot of warning.
Yeah. Okay. I mean, that's and in one sense, so as for a layperson like me, I get to the end of that. So I've given them 14 days. I've given them fair warning. They still haven't met that deadline. I presume you probably want to ring them up again on the 15th day and say, hey, where's this? We're going to go to court. And at that point, I'm seeking out a lawyer who takes legal aid for homelessness cases.
Yeah. Well, this is sorry. I haven't addressed the issue of whether somebody else could write this letter and whether it has to be a lawyer's, because I get used to somebody handing the problem to me and then I have to start at the beginning. But one of the things that I'm keen to encourage, and I know that other people are, is to encourage caseworkers and people who are sort of first contact type people to write these letters. And instead of it saying at the end, if you don't do this, I'm going to issue proceedings, you just insert the words that I'm going to instruct a solicitor I'm going to refer this to a solicitor who will issue. And the firm Dighton Pierce Glynn, who I think are probably one of the best lawyers doing this kind of thing, the firms lawyers doing this kind of thing in London, have set up training for people. It's mainly in sort of migrant type cases against the Home Office, because with the Home Office, there's just usually administrative problems. So if by the time the letter's done, and the time limits run out, they might just wake up. But it's great for a lawyer if the person's done the letter before, because then the lawyer can just say, right, I've been given this letter, you've got 48 hours. Or they can just go straight to court.
And so a non-lawyer can do this provided they are, they're conscientious and they can get the right facts, they can identify the right issues, and they can apply or kind of state what the correct law is. So if they do that right, so I'm going to guess, if you write a letter and you get this stuff wrong, then obviously a legal department's probably just going to either ignore it completely or I mean, I don't know, is there any risk that comes from this in terms of, I mean, I've got around it before with data protection cases where I've just basically written the letter, got the client to have a look at it. If they're happy with it, they sign it in their name and they send it off, and that's worked. So that's still pre-action protocol for stuff. But
and apart from sort of looking silly, if you get it wrong, there isn't really any risk, because you're not. The risk would be if you went and issued court proceedings and it was all, the client hadn't told you that the child actually lives somewhere else. And you were basically not doing your job properly, then you could get costs ordered against you, or you could get into trouble. In fact, in immigration law, they have a procedure in the High Court, because I mean, I shouldn't be too hard on solicitors, but in immigration law, solicitors have been so bad because the Home Office is such an easy target, that they were literally setting up sort of conveyor belts of just issuing proceedings. And they have I've forgotten what it's called. I was just talking to a barrister about its dad. I think it's called the HIMAD procedure, or it's something like that. It's named after a case. But if they think you're taking the mickey, you get summoned to go in front of a judge. The lawyer gets summoned. It's like going to the headmaster's office, and you have to explain what you were doing. And if they don't like it, and they're pretty strict, they will, and not just you, your boss has to go as well. And they'll make, orders against you, and they can sort of stop you doing any of that sort of work again. But mercifully, it hasn't happened to housing lawyers yet. But there'll always be the barrister on the other side looking for, a chance to tell the court that you've done something wrong. But at the pre-action stage, no, it would be fine. And the law, as you can see from my letter there, it isn't that complicated. And you could probably have, if I hadn't included that standard text in there and I'd said to you, well, what are the legal issues? You could have probably come up with those.
Yeah, cool.
So, I mean, with a bit of training, and the other thing that Piers Glynn do, which is really good, is they have a system where once the person has written the letter, and they get funding from a charity for this, I've forgotten who it is, you can write the pre-action letter and then send it to them, and they will proofread it for you and check that you haven't committed a howler, and then you can send it off knowing that it's had a lawyer look at it. Is that I find that quite often making a mistake is, I mean, you shouldn't necessarily do it on purpose, but sometimes it's a bit of a blessing in disguise. Because one thing, if I want to get a fast response from a local housing association or a local government, if I make a mistake in my letter, I tend to get somebody ringing me up or emailing me saying, you made a mistake, you don't know what you're doing. And I say, oh, thank you very much. Can I just make a note of your details so I know somebody's got my letter and is dealing with it? And whereas before they might have waited a week, but a lot of people can't resist. They think, oh, who does he think he is? I'll tell him. And then you can start a dialogue much quicker. And lawyers, particularly, if you write to the legal department to make a mistake, they'll be quick to tell you that you're a useless lawyer, which may miss the point that their clients are still acting unlawfully. But I wouldn't encourage it. But I mean, it's a reason not to be too worried. And at the end of the day, nobody. The thing with the pre-action letter is nobody actually goes into the detail too much, unless there was some allegation that it was fraudulent. Nobody actually reads these later, because when you go to court, you've prepared a full claim which sets out the facts. And that's another story, because you really do. There's a thing called the duty of candor. So I have to tell the judge everything about the case, even if it's not helpful to me.
Yeah.
But that's another story. But at this stage, I mean, there is a duty of candor, but it's, there's another filter in that this isn't the only thing the judge sees.
Yeah. And so in one sense, this works because, housing officers, housing teams, they do really know what the law is, and this is kind of just, this is prompting them. Because my guess would be if they think they're right, they're gonna they'll go to court. If they think that they've got a good defence, they're not going to just fold over. If they think that that the letter was mistaken in some way, because then
Yeah, I mean, my view is that the London boroughs, particularly the ones I deal with, there are people in there that know the law, and there's quite a lot of junior people who don't,
right,
or don't know it as well, and they make mistakes. And so, I mean, that's the kindest way to look at it. They could make a genuine mistake. And so writing this letter is a way of getting them, sort of somebody to tap them on the shoulder and say, I think you made a mistake here. But then there are other, and this one, the further outside London you go and the less the councils deal with housing, I think the higher up the chain that level of making mistakes goes. And so you may have to, I was talking, actually it was a London borough, but I wrote to a London borough the other day and said, can you carry out a needs assessment under section 189A? And I got a letter back saying, oh, we don't actually do those. And that's the sort of response you get from outside London.
I got a fascinating FOI response the other day. So it's Northamptonshire. and I've got a case going on there, but basically I did an FOI to ask them what their training was around the Housing Act. I said, Housing Act 1996, what training your staff get in terms of priority need, and the response was, well, we only use the Housing Act 2004. We don't use the Housing Act 1996. And I'm thinking I'm going to go back to and say, do you want to answer that again? Because that's a really stupid response. For your housing options team to not be using the Housing Act 1996. But yeah,
Yeah, I mean, it's obvious that's obviously got to be a mistake because they presumably got somebody, because they must be with these freedom of information things, that they get somebody incredibly junior to say, look, can you just go to the website and copy and paste a load of stuff in for this one?
I think what they might have done is gone to like the rent deposit scheme or something that is that it genuinely is just kind of only using the Housing Act 2004, which I'd never even heard of before. I was kind of looking into it, thinking, what does it even cover? But yeah, it's yeah, I hear what you're saying. Okay.
But there are some councils though where, I mean, I don't want to name names, but where you get the combination of people who should know better, who are not making mistakes, but are just being, they're digging their heels in.
Yeah.
There, you genuinely need to have a fight, and the letter will give you a warning. At least when you go to court, then you can say, "Well, I did warn them."
Yeah.
So, I mean, if you're interested in